on national values and principles of governance requires that the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Section 14, subsection 1 of the Urban Areas and Cities Act of 2011, as amended in 2019, requires that a board of a municipality shall consist of 9 members appointed by the county governor with approval of the county assembly. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. 1. His Excellency Amos Nyaribo, by the Gazette Notice number 1965 of 2025, dated 30th February 2025, appointed members to the boards of Keroka and Nyamira municipalities.
My work is easy because I use ClickUp. Here's how AI saves me hours every day. It automatically prioritizes my tasks so I can focus on what's important without wasting time trying to figure out what to do next. I can ask Brain about any list to quickly get up to speed. When I need to draft documents, ClickUp Brain helps me get ideas on paper. And questions in our team channel now get automatically answered by an AI agent with expert company knowledge. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
The governor has to date retained the said board members in defiance of clear judicial and senatorial pronouncements. 4. This constitutes a blatant disregard for the rule of law and contempt for legitimate authority. Allegation number 5. Gross violation of the Constitution of Kenya 2010 and the County Government Act 2012 by appointing the selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board, CPSB, without the approval of the County Assembly of Nyamira. Whereas Article 10 of the Constitution on the national values and the principles of governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73 and 74 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 232, subsection 1 of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency, and fair competition and merit. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. 1. The governor appointed a selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board, CPSB, without the approval of the County Assembly of Nyamira. 2. The governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful. 3. The selection panel proceeded to invite, shortlist, and conduct interviews for the applicants for the positions of chairperson, secretary, and members of Nyamira County Public Service Board, in total defiance of clear judicial and senatorial pronouncements. 4. These actions are contrary to the constitutional principles and undermine public service integrity. Allegation number 6. Gross violation of the Constitution of Kenya 2010, County Governments Act 2012, by failing to appoint the chairperson, secretary, and members of the Nyamira County Public Service Board. Whereas Article 235 of the Constitution of Kenya 2010 provides that a county government is responsible for A, establishing and abolishing offices in its public service, B, appointing persons to hold or act in those offices and confirming appointments, and C, exercising disciplinary control over and removing persons holding or acting in those offices. Whereas Section 58A(1) of the County Governments Act 2012 provides that whenever a vacancy arises in a county public service board, the governor shall nominate and, with approval of the county assembly, appoint members to a selection panel for the purpose of selecting suitable candidates for appointment as members of the County Public Service Board. And whereas Section 58A(7) provides that the governor shall, within 7 days of receipt of the names forwarded under subsection 6, nominate one person and at least 3, but not more than 5 others for appointment as chairperson and members of the County Public Service Board, respectively, and forward the names to the County Assembly for approval. 1. The Governor, His Excellency Amos Nyaribo, has to date failed to nominate for vetting, approval, and appointment of the chairperson, secretary, and members of the Nyamira County Public Service, despite vacancies arising in the Nyamira County Public Service Board as from 5th of July 2025. 2. The absence of a County Public Service Board has created a lacuna in management of the human resource function of the county government of Nyamira. In the obtaining circumstances, the provisions of Article 235 of the Constitution of Kenya 2010 cannot be realized in the Nyamira County Public Service. 3. Additionally, this has eroded confidence and public trust in the leadership of Governor Amos Nyaribo. Allegation number 7. Gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by failing to submit annual reports and deliver an annual State of County address to the County Assembly for 2 consecutive years. Article 183(3) of the Constitution of Kenya 2010 provides that the County Executive Committee shall provide the County Assembly with full and regular reports on matters relating to the county. And Section 32(J) and (K) of the County Government Act 2012 mandates the governor to J, I quote, under J, submit to the County Assembly an annual report on the implementation status of the county policies and plans. K, deliver annual State of the County address containing such matters as may be specified in county legislation. 1. The governor has failed to submit annual reports and deliver annual State of the County address to the County Assembly of Nyamira for the past 2 consecutive years, 2023-2024 and 2024-2025, as required by law. 2. This failure constitutes a gross violation of constitutional and statutory provisions, demonstrating a blatant disregard for transparency, accountability, and oversight role of the County Assembly. It further denies residents of Nyamira County an opportunity to hold their governor accountable. 3. The governor's consistent and prolonged failure to deliver the constitutionally required State of the County address demonstrates a deliberate act to evade accountability to the County Assembly and the people, thereby constituting gross violation of constitutional and statutory mandates. Allegation number 8. Gross violation of the Constitution of Kenya 2010 by failing to appoint and obey court orders regarding the appointment of Cliff Ogwora to the County Executive Committee. Whereas Article 159(1) of the Constitution of Kenya 2010 provides for the exercise of judicial authority, whereas Section 14(1)(a) of the Contempt of Court Act 2016 provides that contempt of court includes civil contempt, which means willful disobedience of any judgment, decree, direction, order, or other process of a court, or willful breach of an undertaking given to a court. Whereas the Employment and the Labor Relations Court at Kisumu in ELRC JR number 10 of 2021 ordered the governor to appoint and pay salaries to Mr. Cliff Ogwora. 1. His Excellency Amos Nyaribo failed to appoint Mr. Cliff Ogwora nominee for member of the County Executive Committee, despite the fact that the nomination was cleared by law for appointment. 2. The governor's disobedience of the High Court order directing him to appoint Mr. Cliff Ogwora resulted into the loss of a discreto sum of Kenya shilling 4,417,875. 3. The actions of the governor, including delayed settlement, resulted into loss of public funds amounting to Kenya shilling 6,922,203.75, being the discreto sum plus costs, interest, and other incidentals. Ground 2, abuse of office. Whereas Article 10 of the Constitution on national values and principles of governance require the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Articles 73, 74, and 75 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability, among others. Whereas Article 232(1) of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency, and fair competition and merit. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. His Excellency Amos Nyaribo abused his office in the management and administration of county affairs through the following acts. Recruitment of staff without approved budget, the recruitment frenzy. Whereas Article 10 of the Constitution...
Clerk, just give me a minute. His Excellency, the Governor, we still have a long way to go reading your charges. In the event that you're tired, you may take a seat. We don't want you to collapse while these charges are being read. Proceed, Clerk.
Thank you.
Allegation 1, abuse of office by improper use of his authority in recruitment of staff without approved budget, the recruitment frenzy. Whereas Article 10 of the Constitution on national values and principles of governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73, 74, and 75 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 201(a), D, and E of the Constitution of Kenya 2010 states as follows. A, there shall be openness and accountability, including public participation in financial matters. D, public money shall be used in a prudent and responsible way. E, financial management shall be responsible and fiscal reporting shall be clear. Whereas Article 232(1) of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency and fair competition and merit. And whereas Section 107(2)(c) of the Public Finance Management Act 2012, PFM Act, require that the county government's expenditure on wages and benefits for its public officers shall not exceed a percentage of the county government's total revenue as prescribed by the county executive member for finance in regulations and approved by the county assembly. Whereas Section 8(1)(c) of the County Governments Act 2012, which provides for the role of the county assembly, including approve the budget and expenditure of the county government in accordance with Article 207 of the Constitution and the legislation contemplated in Article 2202 of the Constitution, guided by Articles 201 and 203 of the Constitution. 1. His Excellency Amos Nyaribo presided over and influenced the approval of recruitment of staff without an approved budget as demonstrated in County Executive Minutes MIN number 04/02/2021 of 26 February 2021 in his response to an inquiry from the Controller of Budget. This recruitment was approved by the County Executive with full knowledge that there was no budgetary provision. In the said response to issue number 4 in the question, the Governor alleged that in lieu of the budget, the recruitment was based on the savings made from various separations, which included but not limited to recruitment and resignations. 2. Despite a resolution of a county assembly to freeze new employments on account of lack of budgetary provision for any recruitment dated 1st July 2021, which freezing was never vacated by a resolution of the county assembly. 3. Further, in spite of an advisory from the Secretary of the County Public Service Board dated 29 July 2021 to the County Executive to put the impeached recruitment in abeyance, considering that there is no budgetary provision for any new recruitment. 4. His Excellency Amos Nyaribo has to date proceeded with a recruitment frenzy that has ballooned the county wage bill, making it unsustainable, irresponsible, and imprudent, contrary to the provisions of the Public Finance Management Act 2012. 5. The Governor's influence over the recruitment of hundreds of staff without budget, in defiance of EACC advisory and County Assembly resolutions for political expediency and personal gain, constitutes a clear abuse of office aimed at fiscal plunder and violation of constitutional values and principles of governance. 6. Since the year 2021, when His Excellency Amos Nyaribo assumed office as governor, he has influenced the recruitment of staff without budgetary provision and approval of the County Assembly of Nyamira, and particularly A. In February to April 2021, there was a recruitment of 49 officers. B. The recruitment of Deputy County Secretary, County Attorney, support staff, ward and county and sub-county administrators. C. On March 9, 2023, the County Public Service Board advertised for 358 vacancies. Despite lack of approved budget for recruitment, a recruitment freeze by the County Assembly, and disregard for EACC advisories. The recruitment, projected to add Kenyan shilling 325 million annually, proceeded without any budgetary allocation or approval. D. outstanding arrears to the tune of Kenya shillings 60 million arising from unpaid salaries to healthcare workers for a period of 7 months. Allegation number 2, abuse of office by influencing the appointment of Godfrey Kiriago and Elmelda Nyaberi as Director of County Human Resource Management and Assistant Director Human Resource Management, Payroll Management, respectively. Whereas Article 179 of the Constitution designates the county governor as the chief executive of the county, whereas Article 232 1G of the Constitution of Kenya 2010 mandates fair competition and merit as the basis for appointments and right to equality and freedom from discrimination, whereas Articles 75, 76, and 77 of the Constitution govern the conduct and financial probity of state officers, whereas Section 30 of the County Government Act 2012 provides for the functions of the governor, whereas Section 45 of the Anti-Corruption and Economic Crimes Act of 2003 provides for protection of public property and revenue, whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. 1. In a letter dated 18th January 2021, the County Secretary communicated the decision of the County Executive, an organ presided over by His Excellency Amos Nyaribo, to the County Public Service Board, seeking the secondment of 2 cherry-picked officers, Godfrey Kiriago Nyangao and Elmelda Nyaberi, to the positions of Director Human Resource and Payroll Management, respectively. In response, the chairperson of the County Public Service Board wrote back to the County Secretary demanding that the said offices ought to be vacant and that the process must follow the laid down procedures and legal provisions. 2, the governor influenced the transfer of substantive office holders to create room for the cherry-picked officers and caused irregular integration into the county payroll. 3, by initiating the non-competitive appointment and retention of the cherry-picked officers, the governor violated the principle of meritocracy and demonstrated a profound abuse of his office, leading to a direct and quantifiable loss of public funds, since the 2 officers were hitherto substantively occupied. 4, the governor further influenced the appointment of Godfrey Kiriago to the position of Deputy County Secretary and influenced the renewal of Mrs. Elmelda Nyaberi's contract post her retirement date. Allegation number 3, abuse of office through personal enrichment from receipt of irregular salary arrears of Kenya shilling 5,649,706. Whereas Article 201A, D, and E of the Constitution of Kenya state as follows: B, there shall be openness and accountability, including public participation in financial matters. F, public money shall be used in a prudent and responsible way. G, financial management shall be responsible and fiscal reporting shall be clear. Whereas Article 234A of the Constitution of Kenya 2010 mandates the Salaries and Remuneration Commission, SRC, to set and regularly review the remuneration and benefits of all state officers. Whereas Section 97 of the Public Finance Management Act 2012, PFM Act, requires public funds to be used in accordance with the law and for the purpose of which they were appropriated. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. 1, In September 2021, through the facilitation of the two cherry-picked officers, Mr. Godfrey Kiriago, Director Human Resource, and Elmelda Nyaberi, Payroll Manager, the governor conferred upon himself an irregular salary payment
Show up when it counts. Be home your way. Send money from the UK to over 10 African countries with the best exchange rates at zero transfer fee, delivered in minutes. Download Lemfi today.
of Nyamira lost services and development programs to the tune of Kenya shillings 5.6 million on account of his abuse of office and or his actions. Number 4, the governor has formed a habit of conferring upon himself irregular benefits going by other incidences. For instance, in the year 2019, the governor caused to be paid a retrospective compensation of Kenya shilling 13 million in allowances for housing, bracket, a benefit, not an allowance, and made a double medical claim in form of ex gratia, despite full settlement of his medical bills by the defunct NHIF, all outside of SRC guidelines, which clearly demonstrate a pattern of personal enrichment, abuse of office, and direct violation of PFM Act. 5, this direct financial benefit to the governor constitutes a direct loss of public funds and demonstrates a clear case of personal enrichment through corrupt practices and abuse of office. Allegation number 4, abuse of office through systemic payroll fraud and syndicate, the Kenya shilling 32 million payroll heist. 1, besides an irregular receipt of Kenya shilling 5,649,706, has already established, in particular allegation 2.3, the governor presided over a well-orchestrated syndicate of payroll fraud, which led to massive loss of public funds through huge, irregular, and unexplained salaries and specified and special allowances paid to Mrs. Rose Bosibori Guto, an ECD teacher, bracket Kenya shillings 25,018,852. Ms. Gladys Mora Nyambane, an ECDE teacher, bracket Kenya shilling 1,100,467. And Mr. Isaac Kerongo Onchiri, an ECD teacher, Kenya shilling 700,836. 2, while under oath during his appearance before the Senate's Public Accounts Committee, the governor admitted to have received the illegal benefit. Allegation number 5, abuse of office by influencing dual appointments outside the lawful establishment. Whereas Article 235 of the Constitution of Kenya 2010 states that a county government is responsible within a framework of uniform norms and standards prescribed by an Act of Parliament for A, establishing and abolishing officers in its public service, B, appointing persons to hold or act in those offices and confirming appointments, and C, exercising disciplinary control over and removing persons holding or acting in those offices. Whereas Section 51 of the County Governments Act 2012 provides that there shall be established at the level of each sub-county the office of sub-county administrator, and whereas Section 51(1) of the County Governments Act 2012 provides that there is established for each ward in a county the office of the ward administrator. Further, whereas these offices were already substantively filled in the year 2014, upon assumption of office in 2021, the Governor, Honorable Amos Nyaribo, aware that these offices were substantively filled, deliberately allowed the recruitment of sub-county and ward administrators to fill the artificial vacancies, leading to double appointments and hence double payment of salaries, depriving the county of development funds. Whereas Section 10(5) of the Employment Act 2007 provides for the procedure of change of contract terms for an employee, the Governor, through letter reference NCG/TRNSF/TRNSF/VOL/3/283, dated 27th June 2024, redeployed 10 officers, ward and sub-county administrators, to positions in which they had no requisite competencies, so as to create room for the dual appointments. Allegation number 6, abuse of office through usurpation of powers of the Auditor General and the County Public Service Board, and violation of due process through illegal payroll, audit and demotions. Whereas Article 47 of the Constitution and the Fair Administrative Action Act 2015 enshrine the right to fair administrative action and due process, whereas Article 229 4A(4) provides that within 6 months after the end of each financial year, the Auditor General shall audit and report, in respect of that financial year, the accounts of the national and county governments. Whereas Section 59A of the County Governments Act 2012 provides that the county public service shall A, be independent and shall not be subject to the direction or control of any other person or authority. And whereas Section 59F and Section 61G of the County Governments Act 2012 vest the power to exercise the disciplinary control over and to remove persons holding in the county public service squarely in the County Public Service Board, whereas Section 35 of the Audit Act 2015 provides for the procedure and manner of auditing public entities. 1. In September 2021, the Governor purported to demote more than 100 staff, which action was reversed by the Employment and Labor Relations Court sitting in Kisumu. 2. Further, in May/June 2024, he demoted another 254 staff on the basis of a payroll audit report without the process, usurping the function that falls squarely under the purview of the County Public Service Board. 3. The Governor appointed a payroll audit team without due regard to Section 35 of the Audit Act, approval by the County Assembly or the Auditor General, contrary to legal requirement. 4. Human resource payroll relates to use public funds and can only be audited as envisaged by Article 229 of the Constitution. 5. The Auditor General is the only constitutionally mandated body to audit all state organs, including county governments, and it has not delegated any of her mandates to any institution to carry Nyamira County payroll audit. 6. The action of the Governor to carry county payroll audit without proper authorization or delegation is a straight usurpation of the constitutional mandate of the Auditor General, and therefore in violation of Article 229 of the Constitution of Kenya 2010. 7. Article 226 3 of the Constitution states that the accounts of all governments and state organs shall be audited by the Auditor General. The action of the governor to carry out county payroll audit without proper authorization of the Office of the Auditor General is in contravention of the Constitution. 8. Article 2291 of the Constitution creates the independent office of the Auditor General, and Article 2294 of the Constitution cuts what the auditor ought to undertake. The action of the governor to carry county payroll audit without proper authorization of the Office of the Auditor General and without the knowledge of the office undermines the independence of a constitutional office and is in contravention of the Constitution. 9. Article 2295 of the Constitution states that the Auditor General has the liberty to audit and report on the accounts of any entity that is funded from public funds. Section 34 of the Public Audit Act 2015 provides for periodic audits to be undertaken by the Auditor General at his or her own initiative or upon request by an entity. The Auditor General has audited Nyamira County. There are audit reports and there is no explanation whether the county government found existing audit report inadequate. The governor have not requested the Auditor General to carry out any audit. The governor have not requested for the County Assembly of Nyamira to sanction the Auditor General to undertake any audit. 10. Section 23 of the Public Audit Act 2015 provides for outsourcing of audit services, while Section 24 of the Public Audit Act 2015 provides for engagement of services of technical experts or consultants and professionals in fulfillment of Article 2296 of the Constitution, which states the principal purpose of the audit is to confirm whether or not public money has been applied lawfully and in an effective way. The
heart of Africa, a new kind of school is rising. Freedom International Schools Africa. We are Africa's most affordable IB World School, offering world-class education without compromise. We have strong foundations in education. Our learning begins with identity and ends with global excellence. We are raising critical thinkers, compassionate leaders, world changers who are rooted in Ubuntu and take pride in being African. From early years to primary and middle years, and soon the prestigious diploma program, your child can learn with us until they are ready to join any university of their choice. We have all the IB programs with beautiful boarding facilities, vibrant arts and sports, teachers who love and listen. Every child grows in confidence and purpose. Join our school. January intake is ongoing.
For debate and consideration has not explained. 13. Section 37 of the Public Audit Act 2015 provides for the forensic audits upon request by Parliament or county assemblies to establish fraud, corruption, or financial improprieties in state organs and public entities. The audit report is then placed with Parliament or the County Assembly for debate and consideration where appropriate resolutions and actions to be taken emanate. 14. The Governor therefore usurped the constitutional mandate of the Auditor General, which he arrogated himself to initiate payroll audit without authorization. 15. The County Public Service Board, in their submissions in county appeals matter before the Public Service Commission through the respondent's reply to appeal in paragraphs 12, 13, and 20, affirmed that the Governor singularly commissioned the payroll audit, including appointment of an ad hoc committee that will digest the findings of the audit. 16. The County Public Service Board, CPSB, in a communication dated 15 January 2025, reversed the Governor's purported demotions, explicitly implying that the demotions were processed without the Board's involvement or approval, confirming the usurpation of the Board's mandate. 17. The County Executive Committee, sitting in September 2025, resolved that it was aggrieved by the CPSB's reversal and will be appealing against this decision, fully aware that it has no provision for appealing. An advisory from the county attorney affirmed this is an advisory to the Chief Officer, Public Service Management. This further demonstrates a governor that is hell-bent in usurping the role of the CPSB. 18. The governor's actions bypassed the established legal framework for personnel management, denying the affected staff due process and leading to demoralization and disruption of service delivery. 19. The governor's decision to personally initiate and execute disciplinary action, bracket demotions, based on an irregular audit without reference to constitutionally mandated CPSB or following due process is a clear and unconstitutional usurpation of power and violation of staff members' fundamental rights. 20. The governor's intention to appeal the decision of the CPSB was in any case an act in futility, as the decisions of the County Public Service Board are deemed to be made for and on behalf of the county government. 21. Additionally, the County Assembly, while considering a report of the Sectoral Committee on Public Service Management on staff progression, passed resolutions that included, among others, 1. The reinstatement of demoted officers to their rightful job groups and payment of their full emoluments. 2. The censure of the Chief Officer, Public Service Management, Mrs. Rael Omanyi, and the further resolution to have her step aside for contempt of the County Assembly and its committees. 22. The governor has to date failed to enforce resolution number 2 above, and equally failed to implement the resolutions of the County Assembly in this report. Allegation number 7. Abuse of office by purporting to suspend the Secretary to County Public Service Board. Whereas Section 58(5)(b) of the County Governments Act 2012, as read together with Article 2511 of the Constitution of Kenya 2010, provides that the members of the board may only be removed from office by a vote not less than 75% of all the members of the County Assembly. 1. The above article and or section do not anticipate or confer power upon the governor to cause such an action as suspension of a secretary to the County Public Service Board. 2. His Excellency Amos Nyaribo acted ultra-vires by purporting to suspend the secretary to the County Public Service Board by the letter reference NCG/GVN/legal/VOL .1 dated 2nd May 2023 beyond his powers as provided for in Section 31 of the County Governments Act 2012.
You may proceed, Clerk.
Honorable Amos Nyaribo, how do you plead to the two grounds, guilty or not guilty? Ground 1.
Not guilty.
Ground 2.
Not guilty.
Now, the plea having been taken, we will move to hear opening statements from both teams unless the preliminary matters that the parties would wish to raise. If there are no preliminary matters, we shall move to opening statements, starting with the County Assembly. Yes, Counsel for Governor.
Thank you, Mr. Speaker, sir, and honorable distinguished senators. My name is Elias Mutuma, representing the governor in this matter. Mr. Speaker, sir, you will recall that on 1st of December, we did formally raise a preliminary objection dated 29th of November 2025, which is seeking to have the proceedings before the Senate terminated in a summary manner before proceeding for full trial. Mr. Speaker, sir, I will be arguing this main PO with your leave, and my learned friend, Mr. Atemo, will also raise 2 applications at the end of my presentation. Honorable Senators, the preliminary objection before you is the one dated 29th November 2025.
So, Counsel for Governor.
Yes, sir, Mr. Speaker, sir.
You were to indicate that you're going to raise a preliminary objection so that I give time indication.
Most obliged. Thank you.
Now, if you look at the rule, at Rule 14 of the Rules of Procedure in schedule, in the 3rd schedule, we have 30 minutes to conclude matters of a preliminary nature. I will therefore give you 20 minutes to argue your preliminary objection. I will give the County Assembly 20 minutes to respond and 5 minutes to make your rebuttal, so that we then, the Senate can deal with that. You may now proceed.
Thank you for that guidance, sir, Mr. Speaker, sir. And my
Your
apologies.
time starts running from now.
Thank you. Thank you, Mr. Speaker, sir, for the opportunity. Like indicated earlier, we have raised a PO, the one dated 29th of November 2025, and contains in the Governor's documents at Volume 1. It's a very thin document, Volume 1 of the Governor's documents. A very thin document, Mr. Speaker, sir. Mr. Speaker, sir, the objection that we have raised through this PO is not just about a procedural issue. It boils down to the very core and principles of our Constitution, because the motion that has been presented before you and the resolutions by the County Assembly of Nyamira do not meet the legal threshold. At the end of my presentation, Honorable Senators, you will have no doubt in your mind that the motion before you is based on a foundation that is constitutionally rotten, procedurally fraudulent, and mathematically impossible. I will be submitting that there is only one remedy available for this kind of an incompetent motion, and that is to terminate it before moving for trial. For allowing the procedure to go on to full trial would be to let a nullity in law assume cloak of legitimacy. Mr. Speaker, sir, the core of our objection is that the motion before you does not mean the 2/3 threshold that has been set by our Constitution and the other enabling provisions of the law. This ground is premised on 2 main issues. If the impeachment proceedings were to succeed, then it must have been supported by at least 2/3 of all the members of the County Assembly. And therefore, Honorable Senators, before even interrogating the issues before you, the first call of duty is for you to satisfy yourself that the resolution that has been forwarded by the County Assembly meets that threshold. Honorable Senators, there are only 3 legal provisions that guide on matters impeachment. One is Article 181 of the Constitution, which requires...
Without a doubt, yes, I'll recommend Digitax. Simply the bigger picture, it's the personal touch, the human touch. They have the excellent customer service, because you assign an account manager, a contact person for the tech items, so you know who to go to. You know, you don't have to call the office, and you are to the customer service. Their system is, say, support system-to-system integration, which is very rare. You don't have to incur an extra cost. You just have to worry about the integration and, say, the documentation. It's seamless to use and fits most of the programs or most of the programs of the sales channel that most people use. With Digitax, switching from Teams to eTeams compliance is as easy as riding a bike.
Parliament the power to enact a law that provides for the procedure of removing a governor from office. Pursuant to that mandate, this Parliament enacted Section 33 of the County Governments Act. The provisions of Article 33 are very clear that the threshold must be 2/3 of all the members of the County Assembly. Now, the County Assembly will appear before you and argue that the threshold had been reduced by vacancies that had resulted from death, designation, or other factors. But, honorable senators, the constitutional threshold remains fixed. It cannot be altered. It cannot be amended. And therefore, honorable senators, what is the total number of the County Assembly of Nyamira? At volume 2A of the governor's document, you will come across the official determination of the total number of members of the County Assembly of Nyamira. Honorable senators, who makes a determination on the total number of members of the County Assembly? It is not the Speaker of the County Assembly. It is not the Leader of Majority. It is not the mover of the motion. It is not any member of the County Assembly. That determination on the total number of the members of County Assembly is predetermined by the very institution that has been mandated with matters election in Kenya, and that is IEBC. At page 42 all the way to page 46 of volume 2A of the governor's documents, you will come across a Gazette notice that was published way back in 2022, confirming the total number of members of the County Assembly of Nyamira. So that is the total number, legally declared, legally fixed, that cannot be changed or altered by any member. That number, honorable senators, is 35. 20 elected members of the County Assembly, 11 members as gender top-up, and 4 representing the marginalized. That is the position. That is the legal position. It has never changed at any given moment. So we have no doubt in our minds that the County Assembly of Nyamira has a total of 35 members of the County Assembly. That number cannot be reduced by interpretation, by innovation, or by improvising of any member. So, having that in mind then, honorable senators, what is the 2/3 of 35? I may not be very good in maths, but we've been here before with the Kedicho matter, with the Isiolo matter, and this Senate was very clear that you cannot have half a person. And therefore, when I do my maths correctly, is that at least 2/3 of 35 must remain to be 24. So the question then that this Senate will have to ask itself is whether 24 members of the County Assembly resolved to impeach the governor. Should you find that you do not have 24 people who voted in favor of this motion, there is only one remedy: to send the County Assembly back to the drawing board for them to meet that threshold. Honorable senators, the record before you will demonstrate 2 things. One is that there were 19 members present on 25th of November 2025 that voted to impeach the governor. That is on record. The Hansard speak for itself. 19 members. However, strangely, honorable senators, 23 votes were generated from a total of 19 members who are present in chambers. Section 20 of the County Governments Act gives directions on the procedure of voting. And it says as follows, that any decision of the County Assembly shall be made by members present and voting. That is Section 20. By members present and voting. Their own standing orders, standing order number 67, speaks verbatim Section 20 and says that any decision of the County Assembly shall be made by members present and voting. Now, if we only had 19 members in chambers, they have given you that list. How could they generate more than 19 votes? Honorable Senators, it's a joke of the year. I may not be good in maths, but I'm sure that a total of 19 will never generate 23. On that ground alone, Honorable Senators, this is a flawed motion. It cannot be entertained. I know my learned friends will come here and try to persuade you to proceed to full trial to make a determination. The question is, what will you be calling witnesses to confirm or to adduce evidence on? Their own numbers confirm that they had 19 people, but 23 votes were cast. And what is the explanation they are giving? That there was voting by proxy. I went looking through our Constitution, the County Governments Act, their own standing orders. There is nothing that is known as proxy voting. So what is this concept that is being introduced? Voting by proxy. Honorable Senators, the mandate of a legislator in a county assembly or in Senate such as this is delegated by Mwananchi. You cannot delegate that mandate further by giving someone else that mandate to vote on your behalf. They will produce letters that, incidentally, Honorable Senators, and this is very important, those letters were never tabled on 25th of November 2025 before the floor of the County Assembly. Those letters were not forwarded at the beginning when this resolution was forwarded to Senate. Those letters only emerged on 1st of December 2025 when now they were presenting their second set of documents. Honorable Senators, what is this voting by proxy? Section 20, and I repeat because this is very important, it says, unless otherwise provided by the Constitution, written law, or any other law, voting shall be by members present and voting. Decisions shall be by members present and voting. I dare the County Assembly to give us evidence of where voting by proxy has been provided elsewhere, either in the Constitution, the County Government Act, or their own standing orders. There is none. So where the law is clear on the procedure, you cannot innovate, you cannot improvise, you cannot interpret it to suit your illegal intentions. But assuming for a moment, Honorable Senators, that even voting by proxy is allowed, was there then voting by proxy? Before you, Honorable Senators, are affidavits by the 4 members that are said to have given instructions to vote. One of them in her affidavit that she is not even in Kenya. She is in Kansas, United States of America. On the very day, she had not seen the motion, she had not read the contents, she had no idea that this was happening. Yet someone purports to have gotten instruction on her behalf to vote. We have Julius Obonyo, we have Elijah Sagwe, Priscilla Nachichi. They have all sworn affidavits stating that they were in Mombasa on 25th when this motion was being passed. They have sworn under oath that they did not give anyone instructions to vote on their behalf, assuming even proxy voting was allowed. This is a clear case of not just fraudulent misrepresentation and forgery, but it's an issue that this Senate should take seriously and recommend criminal charges against the perpetrators of this heinous act. There was a reason why the enactors of our Constitution demanded that decision must be made by members present and voting. Your own standing orders, honorable senators, and I've been here before, there are two ways of being present and voting. Either you're physically present in chambers where bars are drawn, or you appear virtually. And even as you appear virtually, I'm here, the speaker must confirm that it is this person who is a non-register of this legislator of this house that is voting virtually. The speaker goes further to confirm that you are actually properly dressed in a parliamentary way. So it's not that automatic that you'll be allowed to vote even virtually. How then would a letter suffice? This motion, honorable senators, cannot be allowed to proceed to the next level. Doing so would be to legitimize a process that is fraud, a process that is meant to thwart the will of the people through their elected representatives. And luckily, honorable senators,
Prestige, tried and tasted.
honorable senators, you do not need to call witnesses. My learned friend Katwa Kigen brought 18 witnesses here in the Kericho matter. How cumbersome was it? That thing ought to have been ended at the preliminary. I dare submit. Do the same today. You did it in Kericho 1, you did it in Isiolo. These are not proceedings that can be allowed to go to the next level. The other issue, because of time, let me just raise it, because I only have 3 minutes. Honorable senators, should this motion then proceed to the next level, we have made an application through a letter that we have forwarded to the Senate, calling for the Speaker of the County Assembly, and this letter is the one dated 2nd December 2025, which makes an application to have the Speaker of the County Assembly and the Clerk of the County Assembly to be summoned to appear before you and produce the original letters that are purportedly given to the Speaker, allowing for proxy voting. I say I have 3 minutes. I want to spare them for the rejoinder. My humble submission to you, honorable senators, we could be done before lunch hour today, because there is nothing that is before you. What you have is a stillborn child. What you have is a lifeless motion that cannot be entertained. Honorable senators, unless you have any questions for me, I beg to submit that these senators have other crucial businesses to attend to other than attending to a stillbirth motion. Thank you. I rest my case.
Counsel for the County Assembly, your 20 minutes starts running from now.
Good morning, Mr. Speaker, sir, and honorable senators. Mr. Speaker, sir, and honorable senators, it is our argument that the issue being advanced in respect to Nyamira is very different from the one for Kericho, and I'll come back to that. But I want to start from where Kericho 2 was left. Being that when we raised the preliminary objection, the general position of the Senate was that the people of Kericho, on their complaint brought in through their MCS, should be heard. Mr. Speaker, sir, and honorable senators, we pray that the same be applied in respect to Nyamira, that this matter proceeds and you hear the concerns of the people of Nyamira, and if it necessarily will entail you are having to combine a determination of the preliminary objection together with the merits of the issue, we, Mr. Speaker, sir, and honorable senators, my learned friend's argument on the preliminary objection was that probably we could just agree on the bottom lines. The first bottom line is we agree that in the year that were sitting or were supposed to sit in Nyamira County. However, as at November 2025, there were only 32. With that, and says that you should determine the 2/3 based on the figures determined by IBC. And for purposes of advancing that argument, they brought in volume 2 at page 42, at page 9 to 42, in which they provide the list of the MCAs that had been elected, and says that IBC has determined that issue of the number of MCAs for Nyamira and cast it in stone. And I would like to read the phrase used by IBC on that issue. The IBC said that the IBC declares, page 9, that page 9, volume 2A, page 9, volume 2A of the governor's bundle. It states that, I'll just read the last 3 lines, honorable senators. It says that IBC declares that the persons whose names, page 9, volume 2A. Just a minute. I want you to read this for me. Honorable senators, if we have found it, I will kindly read this. That page 9, that is where the declaration of the results are set out. Just read it.
Honorable senators, it reads, IEBC declares that the persons whose names are listed in the schedule hereunder were elected as members of the various county assemblies.
You may be having a different volume 9.
Honorable senators, it is volume 2A of Governors 2A.
2A, page?
Yes. Page 9.
Page 9?
Yes.
Yes, page 9, yeah?
Yes.
Yes.
It is titled The Constitution of Kenya. The
Yes.
Independent.
Yes.
Thank you, Mr. Speaker.
You may proceed.
Okay.
Mr. Speaker, it reads that the IEBC declares that the persons whose names are listed in the schedule hereunder were elected as members of the various county assemblies, having received the majority of the votes cast in the election held on 9th August 2022 and complied with the provisions of the Elections Act 2011 and the Constitution.
Thank you very much. Mr. Speaker, sir, our argument then is that the IEBC was not saying that is the limit and the absolute number of the members that were at that time or at any time to sit in the County Assembly of Nyamira. The specific issue of the County Assembly of Nyamira is captured at page 42, where the numbers are set out, and then thereafter the top-up figures are provided for. Now, Mr. Speaker, sir, and honorable senators, the point I'm making is this, that when the Constitution and the County Governments Act states that it is 2/3 of all county assembly MCS, it can only be referring to the MCS at the material time. It cannot be an absolute. That if, for instance, you have 10 people died or the election have been nullified, then the county assembly cannot function, or that if you have somebody who is misconducting himself, like in this case, the MCA's case in respect to the governor, then you cannot do anything. And Mr. Speaker, sir, and honorable senators, I just pray that you juxtapose that argument with the fact that in Kenya we had for a very long time a lack of IBC. Is it the case then, or will the senators then take the proposition that where we have limitation in the process of filling up the positions in the county assembly, then no activity should go on? Secondly, the county assembly over time has been passing appropriation bills, has been making legislations. If you were to hold that the 2/3 must be out of the 35, the ideal 35, are you then saying that all the legislations that have been passed, all the appropriation bills that have been passed, were all null and void? It is our argument that the intention of the Constitution and the County Governments Act is that it's 2/3 of the people who were there at the material time. Now, I should probably just explain and account for the 3 that brought the shortfall from 35 to 32. The first one was one Honorable Thaddeus Nyaboro, who was elevated to be a speaker and resigned, and his replacement was done on 1st of December. The MCA replacing him was done on 1st of December. The next MCA who left the scene was one Elijah Osiemo, who passed on in August 2023, and the third one is Doris Kiboso of Nyasiongo Ward, whose election was nullified. And therefore, the County Assembly of Nyamira has been conducting their affairs using the 2/3 of the MCAs that remained. So it is my argument, honorable senators and Mr. Speaker, sir, that you do agree with us that the use of the word all, both in the Constitution and in the County Governments Act, was contemplating and expecting the use of the people in office, short of which it would mean that the county assemblies and probably the Senate for that matter and probably the National Assembly cannot conduct some affairs until when vacancies arise in the body of the membership. It is also our argument, Mr. Speaker, sir, that to the extent to which it will be necessary to determine whether it was intended that 2/3 is an absolute figure from the total number of the elected MCAs, number one. Number two, whether the IBC's notice is to be treated as an absolute, as casting the total in stone. Those two questions are questions of fact, Mr. Speaker, sir, and honorable senators, and it is our argument that you should allow this issue to go into full hearing and a determination be made on that issue. Mr. Speaker, sir, I would like then to move on to the issue of proxies. My learned friend has said that the letters upon which the people who exercise voting rights on behalf of others were not produced in the assembly. Mr. Speaker, sir, in our disclosure, in our documents, we've shown the letters by which the powers were delegated to some individuals to vote on behalf of others. Now, my learned friend's argument was that you should take it for a fact that indeed those letters were not at the assembly. It is my argument, Mr. Speaker, sir, and honorable senators, that to the extent that you will need to determine whether indeed those letters were there is a question of fact, and therefore we should go to full trial. Secondly, Mr. Speaker, sir, my learned friend has argued extensively saying there is no provision for use of proxies. Mr. Speaker, sir, and honorable senators, I pray that right away you take judicial notice of the fact that you yourself, as a Senate Assembly, use proxies. And therefore, to the extent that the Senate uses proxies as a means of determining its affairs, it be treated that use of proxies is a normal process of legislative processes, and therefore the fact that it has been used in Nyamira is not necessarily wrong, considering that it has been used in this. And Mr. Speaker, sir, I would just want to invite you to the fact that the Nyamira County Assembly has previously used the proxies, and we would like to have an opportunity to adduce evidence to that effect when we come to the full hearing. Mr. Speaker, Standing Order number 67, my learned friend said that I will not be able to refer to. And Standing Order number 67 of the County Assembly, Nyamira County Assembly Standing Orders provides for 3 means of voting. That is secret voting, roll call voting, and electronic voting. Now, roll call voting and electronic voting is extensively described in the Standing Orders. The secret ballot voting system is not extensively explained in the Standing Orders, and that therefore leaves room for the Speaker to use Standing Order number 1 and give guidance. In the specific case of this voting, which is the subject of the impeachment that has been placed before you for determination, the issue of the use of the proxy was presented to the Speaker. The Speaker was invited to the fact that some people have sent authorities authorizing and giving proxies powers to vote on their behalf. Those documents were produced, therein they answered. And Mr. Speaker, sir, the Speaker of the County Assembly, in exercise of his authority under Standing Order number 1, authorized the use of the proxies. And therefore, Mr. Speaker, sir, it is our argument that that process was use of the proxy was properly considered, evaluated, and determined, and that it is properly allowed by Standing Order number 1 and Standing Order number 67. Mr. Speaker, sir, I would like to cede the remainder of my minutes to my learned friend, Mr. Mokua, on the 2 preliminary issues.
Thank you, Mr. Speaker, sir, and honorable senators. For record purposes, my name is Mr. Mukwandobi. Mr. Speaker, sir, in determining this preliminary objection by the governor's side, we urge this Senate to be guided by the elements of a preliminary objection as espoused in the most celebrated case of Mukisa Biscuit. Mr. Speaker, you will agree with us that this particular preliminary objection fails all the 3 tests that was set out in that very old case. First of all, Mr. Speaker, sir, a preliminary objection is supposed to be purely on a question of law. Mr. Speaker, wherever there are questions of facts to be interrogated, then a preliminary objection ought to fail, as is the case before the Senate. Mr. Speaker, there is a contestation as to the exact number of the MCAs in Nyamira as at 25th November 2025, when this impeachment motion was taken. On the governor's side, they are contending that the MCAs in Nyamira were 35 in number. On the assembly side, we are contending that the total number of MCAs were 32 in number. Therefore, Mr. Speaker, there is a contested question of fact, even on the baseline, on the total number of MCAs that were present in Nyamira County Assembly, as that preliminary objection does not meet the second element in the Mukisa Biscuit, is that a preliminary objection is raised and argued on the assumption that all the facts that have been raised by the other side are correct. Mr. Speaker, the governor has filed an affidavit together with his witnesses. This therefore means he is contesting the factual issues that have been raised by the county assembly. To that extent, Mr. Speaker, the matter has to go for full trial so that the senators can make their own independent determination on the factual issues that are being contested. Mr. Speaker, in the Kericho 1 impeachment, there was general consensus, both by the governor's side and the assembly, that the total number of MCAs were 47 and that those who voted were 31. So what was left for the Senate was to determine the threshold, whether it is 31 or 32. And that impeachment collapsed at that juncture. But in Kericho 2, there were contested factual issues, and that is why the matter had to go for full trial, and then eventually the senators had to rule on the issue of the threshold. Mr. Speaker, it is our submission that the position in Kericho impeachment 2 is the one that is obtaining in the present impeachment proceedings. There are highly contested issues of fact which cannot be determined summarily at this preliminary point. Very finally, on the third limb as to why this particular PO ought to collapse, Mr. Speaker, a preliminary objection ought not to be raised where issues of discretion are to be determined. Mr. Speaker, sir, the Nyamira County Assembly standing orders, especially standing order number 1, vests power upon the Speaker to exercise discretion and to rule on procedural aspects which have not been expressly provided for in the standing orders. To this extent, Mr. Speaker, to the extent that the governor's side is challenging the Speaker's exercise of his discretion to allow voting by proxy, the preliminary objection ought to collapse on that ground. Is challenging the Speaker's exercise of his discretion to allow voting by proxy, the preliminary objection ought to collapse on that ground. Mr. Speaker, counsel for the governor has indicated that these particular 4 MCAs never delegated their power to vote. On our end, it is our case that they did delegate. Sincerely speaking, Mr. Speaker, at this juncture, how can a tribunal or a Senate sitting at this juncture, how can it believe the governor's side and fail to believe our side merely because we are being told affidavits have been filed? Mr. Speaker, if we are allowed to proceed for full trial, we will bring for you a phone where this particular one of the MCAs did send a letter on WhatsApp. We will provide the phone in its original form. We will also provide email correspondence by these particular MCAs who are alleging that they never allowed to be voted for by way of proxy. Mr. Speaker, under the doctrine of silence of laws, where an act of parliament is silent on a particular item, then generally that particular act of parliament does not provide for a certain action, and at the same time, it does not prohibit a certain action. To the extent that the Nyamira County Assembly standing orders are silent on the act. It is our case that the 2/3 threshold was not just met, it was in fact surpassed. This, Mr. Speaker, we can only demonstrate once we proceed for full trial. On the second limb, Mr. Speaker, of the issue of summoning the clerk and the Speaker of the Nyamira County Assembly, we pray if our colleague can drop that particular request. We do undertake to avail one witness, the one who was given the 4 documents. He will avail the documents, he will also avail his mobile phone, and he will also avail the email to which this particular document was sent to him. Mr. Speaker, sir, we do pray that you dismiss this particular preliminary objection, allow this matter to proceed for full trial, so that the whole world can be able to see the atrocities that have been committed on the people of Nyamira County by His Excellency the Governor, Amos Nyaribo. Mr. Speaker, sir, we humbly pray that you dismiss this preliminary objection in the alternative, determine on the PO as their first issue. We humbly submit. Thank you.
Now, Honorable Senators, pursuant to Standing Order 34, 2A, I will allow later interruption of the proceedings at 1:15 to allow a rejoinder from the team of the Governor, and thereafter allow Honorable Senators, if you would wish to seek clarifications or ask questions to any of the parties present. Counsel for Governor, you may proceed with your rejoinder.
Thank you, Mr. Speaker, sir.
5 minutes.
Mr. Speaker, sir, with your permission, I had reserved 3 minutes.
Okay.
For my yes. Thank you.
Those are 8 minutes.
I will use 3 minutes, then my learned friend will proceed. Mr. Speaker, sir, pleadings in respect of this impeachment were closed on 1st of December 2025. All parties were required to file their respective document as at close of business on 1st of December 2025. There has been no attempt by the County Assembly to respond by way of affidavits, controverting the affidavits that are on record by the 4 MCAs. None. They had that opportunity, they did not do it. And therefore, in respect of that piece of evidence, it is uncontroverted. That is the position. That is a fact that has been admitted because they had the opportunity to file their own affidavits to respond to this issue. They have not. And therefore, we are squarely within the... Secondly, and lastly, Learned Counsel has sought to seek refuge under Standing Order number 1 of the County Assembly of Kericho. Let me remind him what the Constitution states at Article 181, that Parliament shall enact legislation providing for the procedure of removal of a county governor on any of the grounds specified in Clause 1. Pursuant to that power, this House enacted, which, in case Learned Counsel has not read, states as follows: except as otherwise provided by this Constitution, this Act, the County Governments Act, or in any other legislation, any question proposed for decision by the County Assembly shall be determined by a majority of the members of the County Assembly present and voting. Can you be present in absentia? It's an oxymoron. When he runs and seeks refuge at Standing Order number 1, standing procedure, therefore the Speaker cannot run and innovate when there is a clear provision of the law. Thank you, my learned friend.
Mr. Speaker, thank you. For the record, my name is Zelma Bunuke, Counsel for the Governor. I'll address the issues that have been referred to by the other side of the County Assembly. I've heard them urge the issue of Kericho and how the proceedings of this House were concluded. It will be noted and on record that upon the proceedings being terminated, the Senate resolved to vote on the PO first before delving into the other grounds. What then does that mean, Honorable Senators? We do not have to waste time on an illegality at this space. As my colleague said, the Honorable Senators have a lot to do, and we have highlighted a significant point or question of law on the threshold. Let me take you through what constitutes of the Nyamira County Assembly. It has got 20 elected members, 11 of which form the part of the gender top-up, 4 in the marginalized category. That is 35. Nothing changes. I will put contexture to that while referring to the Constitution of Kenya under Article 138 on the election of the President. Allow me, Honorable Senators, to refer to Article 138 for A, which says, in a presidential election, a candidate shall be declared elected as a president if the candidate receives A, more than half of all the votes cast in the election, and at least 25% of the votes cast in each of more than half of the counties. Honorable Senators, we have 47 counties in Kenya. Half of that, my quick math tells me that is 24. Therefore, the express provision of this, of the Constitution is that we cannot then say that if 38 counties voted, then they did not meet the threshold, because the law is clear that they have to be more than half of it. So what you're being told here is that we need to subtract the members who are not present and then lay the basis of having the 2/3. Allow me to refer to the Constitution once again on the process of the removal of a governor. It's very clear. It is not something that has been created out of anything else, but it's in the Constitution. The framers of the Constitution were very specific under Article 33(1), and I will read Article 33(2). Sorry, this is the County Government Act, Section 33(2). It is specific that a motion under subsection 1 is supported by at least 2/3 of the members of the County Assembly. This, honorable members, is a specific motion. It is not a bill or any other motion that can be brought to the House. It is particular to the removal of a governor. We do submit, honorable senators, that even if the County Assembly Speaker sought to create his own rules on how to conduct this voting exercise, then the standing order number 1, which they have sought to rely, is very specific, and they have read selectively standing order number 1(1). What they didn't tell you is that standing order number 1(2) provides as follows: the decision made in paragraph 1 shall be based on the Constitution of Kenya, statutes of law, and the usage of forms, precedent, custom, procedures, traditions of the County Assembly of Nyamira, the County Assembly, and the Republic of Kenya within this jurisdiction. They have failed to refer you to any statute that provides for proxy. You have also been told that this is a norm at the County Assembly of Nyamira to use proxy voting. Then we pose this question, honorable senators. Should we then countenance an illegality on the face of it, which has these serious ramifications, including impeaching an elected governor on a basis that does not exist in law? Honorable senators, we urge you to consider our preliminary objection, and especially on this point on the threshold. If you are told that the issue of proxy have to be called as witnesses, that is fine. But then have we determined the first question on whether this motion met the threshold? The answer is a resounding no. We yield to that, honorable senators. Thank you.
Now, honorable senators, we have 6 minutes. Kindly shoot straight so that we can extract the most out of these 6 minutes. Senator for Nairobi City County.
Honorable Speaker, very interesting arguments have been made about membership, and I want to seek clarification from Council, especially Council for the Governor. On the question of membership, you have stated very well what Section 33(2) speaks about, that motion has to be supported by 2/3 of all the members of the Assembly. I want you to tie that to the provisions of Article 103(1)(a) on vacation of office. Upon the death of somebody, can that person be still referred to as a member of the Assembly for purposes of determination of membership? And therefore, Speaker, there is a very interesting point that was raised by Council for the Assembly. For instance, Speaker, if by catastrophe we have 35 members in the Assembly, 15 of them are in a bus, and the bus plunges into a river and they are no longer members of the Assembly. If an issue of impeachment were to arise in determining 2/3 of those members of the Assembly is it the case for the governor that we will still use the number that was determined at the election in August of 2022? Thank you, Honorable Speaker.
There's counsel for governor.
Thank you, Mr. Speaker, sir, and thank you, Senator for Nairobi, for that question. My straight answer to that question is the impeachment process is governed by 3 pieces of legal provisions: Article 181, Section 33, and the standing orders. It does not anticipate a scenario whereby there will be a vacant that will have to last for so much, or rather for so long, such as to affect the business of the House. And let me just give this as an example. Assume that for a moment, half of the House is not present, either by tragedy or disaster. What happens to that House? Do we then reduce the threshold to the remaining 10 or 5? We cannot do that. So if there is a vacancy, it does not affect the threshold because the law has a mechanism of filling that vacancy. That would be my short answer to that issue. Thank you.
Senator Wambua.
Mr. Speaker, I have a similar question, but this time to the Counsel for the Assembly, Catra Keegan. Mr. Speaker, I want the lawyer to address me and address this House on the question of the membership of any assembly. At what point does that membership determine? Does it determine immediately after elections and after political parties have had an opportunity to discharge their obligation to nominate members? Or is it a moving target? Is it one number today, a different number tomorrow, a different number next week? At what point does this number determine? I thank you, Chair.
The Counsel for the County Assembly.
Thank you, Mr. Speaker, sir. It is the direct answer to the question from us is that it is a moving target. The reality of it is that at every given time, the representation has to continue. Various activities have to be done. There is need to approve budgets, there is need to determine issues, and therefore the fact that there is a continuous need to attend to issues on behalf of the public makes it a moving target. And at every given time, the people who are available to transact the business on behalf of the people who elected them is the determining factor of the total bottom line number of people who are to vote. That's my answer to the question.
Senator Boni.
Mr. Speaker, I'm convinced by what the Counsel for the Governor Mutuma has said, that voting by proxy, you can't find it anywhere in the standing orders of the County Assembly or anywhere else. And yet, this is going to guide us to decide on your PO, Mr. Mutuma. Don't you think reading standing order in its entirety, we should give the County Assembly an opportunity to demonstrate to the House that the Speaker proceeded under standing order number 1 of the County Assembly, allowed by proxy, and maybe he did so because of some usage, some tradition that preceded that decision. Don't you think we should allow this to proceed so that we hear evidence to make a decision instead of just condemning them? No, you are wrong.
Counsel for Governor, you have a few seconds to respond.
Thank you, Senator Boni Halwale. An argument based on points of law or the interpretation of law cannot be a factual issue. It is based on legal arguments. they had that opportunity to submit, and that's why this Senate directed us to prepare written submissions and bring them before this House. That is why they've been given 20 minutes to demonstrate to you through legal arguments how the Speaker can rely on Standing Order number 1. There is no witness who is coming to testify on a question of law. It is purely an interpretation issue which does not require evidential interrogation. The purpose of going through a trial, honorable senators, is for you to look at the facts, to cross-examine the witnesses on their version of factual issues, and then render a decision of fact. Questions of law.
Counsel for Governor, time
Thank you.
Up.
Thank you. Thank
Honorable
you,
senators, I will be giving my ruling at 2:30 on this particular matter. All right. Now, honorable senators, it is now 1:15 p.m., time to adjourn the Senate. The Senate, therefore, stands adjourned until later today, Wednesday, 3rd of December, 2025, at 2:30 p.m.